Alfred DeWayne Brown for the capital murder of Charles Clark, an HPD officer, during the botched robbery of Ace check cashing employee Alfred Jones. On October 25, 2005, Brown was convicted of capital murder and sentenced to death. The day before a writ of habeas corpus hearing in 2013, the district attorney and the defense lawyer agreed to recommend to Texas's highest court that relief be granted, that Brown's conviction in the capital murder be reversed, and that Brown be granted a new trial. On November 5, 2014, the Texas Court of Criminal Appeals agreed to exactly that. And on June 8, 2015, the district attorney dismissed Alfred Brown's capital murder case. The reason given by the then DA was that the state could, quote, not prove its case beyond a reasonable doubt. A re-review of the case was requested by the defense soon after I was sworn into office. This request was just one of dozens. On May 2nd, 2018, I appointed John Raley as special prosecutor. I did that because John is a nationally recognized expert on such matters. I asked him to analyze three things. One, whether Brown should be re-indicted and tried. Two, whether he should be declared legally innocent. Or three, whether the status quo of dismissed charges, absent a formal declaration of innocence, should continue. Yesterday, John Raley submitted his final report to me, detailing his conclusions, which he will report to you momentarily. I accept his findings. And let me say that before our announcement is even complete, that there are those who will disagree. That happens every time a district attorney anywhere makes a decision of this magnitude about a person's life. Mr. Raley?
Thank you, District Attorney Ogg. On November 3rd, 2003, between 9:39 and 9:46 a.m., at the Ace check cashing store at 5700 South Loop in Houston, Alfred Jones and Officer Charles Clark were brutally murdered in a botched robbery. I was asked to review the evidence regarding Alfred DeWayne Brown, who spent around 12 years in prison, around 9 of it on death row, as to whether he should be re-indicted or declared actually innocent, or the status quo left where it is, with charges dismissed but with no declaration of innocence. Our staff spent around 1,000 hours so far reviewing the extensive evidence in the Brown case, multiple investigations from multiple sources, trials, appeals, as well as the investigation of Elijah Jobert and Deshaun Glaspie. Their investigations, their trials, their appeals. Deshaun Glaspie pled to a lesser count of armed robbery because he was the state's chief witness against Brown and Jobert. We have now completed our findings. We have a report that's 179 pages long. We have enough copies, I think, for each news service to have one. I think that it will be posted online shortly. A few basic comments that I hope you agree with. None of us must ever be afraid of the truth. It does no justice to Officer Clark to convict the wrong person. We now know that the 10:08 phone call between Erica Dockery's landline and Alma Berry's landline where Erica Dockery was working at the time, was linked probably as a three-way call with a 10:07 phone call from the Via America's apartment to Erica Dockery's. We now know that the person whose landline was used at the Via America apartment to call Erica Dockery's landline as the first leg of that linked call gave 5 statements over a 12-year period that only 2 men were in her apartment at the time, Glasby and Jobert, that Alfred DeWayne Brown was not there. Brown has always maintained in this case that at that time he was at Erica Dockery's apartment. Erica Dockery's then 18-year-old nephew also confirmed that Alfred DeWayne Brown was there. And Brown was on that call. So if Brown was on that call, he had to have either been at Dockery's apartment or at the apartment at the Via Americas. And the evidence is he was at Dockery's apartment. Only one getaway car was used. You'll see in the report on page 44 a map where we describe the times and distances. I have a blow-up here if we need to get into that. But there is absolutely insufficient time in the one getaway car to drive from the crime scene at 9:46, which is the time the electronic door registered, which is absolutely the earliest time that the criminals could have left the crime scene, drop Brown off at Erica Dockery's, and then drive to the Via Americas to make the first leg of the call. It cannot be done. If these 3 witnesses are testifying truthfully, and we have no evidence whatsoever that the woman at the Via Americas has a bias for or against Brown, and she has always remained consistent. Of the 38 witnesses in this case, only 2 have never materially changed their stories. This woman and Erica Dockery's then 18-year-old nephew. They are testifying truthfully. Brown could not physically have been at the crime scene. There is other evidence that we analyzed in some detail. I think it's important to note that the principal evidence against Brown at trial was the testimony of Deshaun Glasby, who was trying to avoid a murder charge personally, and he was successful in that. He was not charged with murder. He was allowed to plead to a lesser count of armed robbery in exchange for his testimony against Brown and against Jobert. The evidence shows that he was not truthful in that testimony. His gun was used to kill Alfredia Jones. That is a matter of fact that is established multiple times through the evidence. He bragged to 3 people that day that he killed Alfredia Jones, and yet he was allowed to walk on a murder charge by Assistant District Attorney Daniel Rizzo, who was handling the case at the time. He was allowed at trial to tell a ridiculous story that he, Glasby, loaned his prized .45 to Jobert, and he, Glasby, went into an armed robbery unarmed. It's incredible that anybody could actually believe that, but that was the story that ADU Rizzo allowed Glasby to tell at trial in hoping to convict Brown. Multiple eyewitnesses described the 3 assailants, the 3 criminals, as 1 tall, 2 shorter. Glasby is tall. Brown is also tall. Jobert, who was there, is shorter. Logically, we should be looking for a 3rd shorter person. The report identifies 3 potential suspects. It could be one of those 3. It could be someone else. But one of those potential suspects was seen by 2 separate witnesses on the morning in question in the car that was used with the getaway car with Glasby and Jobert as guns are being loaded. And this suspect was not even put in a police lineup for witnesses to identify, nor were the other potential suspects that we identified. The bottom line is that Assistant District Attorney Rizzo jumped to conclusions and convicted an innocent man. He signed an affidavit on March 31st, 2012, during the workup for Brown's habeas corpus review. In his affidavit, he said, "I did not suppress information about a landline call from Erica Dockery to Alma Berry." The evidence suggests that that affidavit is not true. The evidence shows that ADA Rizzo was fully aware of the Dockery landline records. that he understood the importance of the records and that he failed to produce them to the defense and the court in violation of Brady versus Maryland, United States Supreme Court precedent since 1963. You may be aware, because there has been some report of it, of an email from Officer Breck McDaniel dated April 21st, 2003, describing the content of the landline records. We put a photocopy of the email in the report. The email says that the landline records are consistent with Alfred DeWayne Brown's alibi that he was at Erica Dockery's apartment around the time of the crime, and that there was a 10:08 phone call to Alma Berry's. This was on April 21st, 2003, the month of the murders. 2 days later, on April 24th, 2003, ADA Rizzo filed an application for these records and an form of order granting them. The records had already been obtained by U.S. Deputy Marshal Richard Hunter as an exigent circumstance. Southwestern Bell wanted a court order in their file, and so this was obtained. It's very important to note that the application and order filed by ADA Rizzo were verbatim to the form of application order Officer Breck McDaniel attached to his email, with one exception. The cite to the Code of Criminal Procedure was deleted. And you'll see from Breck McDaniel's email that that was the very thing Breck McDaniel was concerned about. Please check this cite because I'm not sure whether it's accurate. This is solid evidence that Rizzo was aware of the content of the email and acted on it, and surely was aware that it was consistent with the alibi of Alfred DeWayne Brown. On April 24th, 2003, on May 2nd, 2003, Breck McDaniel filed an offense report where he said that he had explained the phone records to ADA Rizzo, including the landlines, and made himself available to answer any questions about it. Now, what happened to these records? We know that during the writ preparation, Breck McDaniel found a copy of the records in his garage and produced them to Assistant District Attorney Lynn Hardaway, who immediately photocopied them and gave them to Brown's defense team. Breck McDaniel has been accused, falsely, it is our understanding, of keeping the original records in his garage. The evidence we have uncovered shows that that is not true. From 3 different sources, one of whom is Breck McDaniel, but also Deputy U.S. Marshal Richard Hunter and Officer D.L. Robertson, all confirmed that Breck McDaniel filed the original Dockery phone records in the police file. Before doing so, he made a copy for himself of those records because he anticipated testifying in the future about telephone records. He was evaluating cell phone evidence at the time. So he made a copy for himself, but he filed the original in the file. Richard Hunter has signed a sworn affidavit, Deputy U.S. Marshal, that he saw Breck McDaniel filing them in the police file. D.L. Robertson remembers them and remembers seeing them filed in the police department file. We know that they were filed. The evidence shows that ADA Rizzo knew that they were exculpatory, and yet they were never produced to the defense, and years later during the habeas, they were not in the file. What happened to them, we do not currently know. That will require further investigation. But we know that at trial, ADA Rizzo avoided the 1008 phone call. In the presentation of evidence during the trial, they jumped from one cell phone call before it to another cell phone call after it. And in response to the evidence that Alma Berry, Erica Dockery's employer, saw caller ID on the phone call as coming from Erica Dockery's apartment, ADA Rizzo, on closing argument, said that she has trouble seeing and she's just wrong about that. Well, she was right about that. The phone call came from Erica Dockery's apartment at 10:08. So, how was Brown convicted? I'll wrap this up and then I'll take any questions you have. The grand jury was abusive and offensive. We've quoted portions of it in our report. One woman was threatened with sexual assault in prison if she didn't tell the story that the grand jurors wanted to hear. One woman was threatened with having her children taken away. This woman was actually jailed for several weeks until she told the story that ADA Rizzo wanted her to tell. An active duty police officer was foreman of the grand jury investigating the murder of a police officer. The bottom line, Alfred DeWayne Brown was convicted in 2005 based on concealed evidence, and since then the case against him has only grown weaker. Now there is no evidence sufficient for a reasonable juror to find that he is guilty beyond a reasonable doubt, which is the legal definition of innocence. And Alfred DeWayne Brown is innocent as a matter of law. I will take any questions you have.
In your opinion, based on what you've done in your report, who should be behind bars or possibly on death row for the murder of the officer Clark and Alfredia Brown?
As I shared with you, the evidence is that Alfredia Jones was killed with Deshaun Glaspie's .45, and that he bragged to 3 people that day in curse words that she got out of line and he had to shoot her. You'll see that in the report. Jobert was unquestionably there as part of the robbery, which resulted in the murders of 2 innocent people. Further investigation will be necessary to determine who the murderer of Jobert was, but this is an ongoing investigation. My request was to evaluate Alfred DeWayne Brown's role, if any, in the events between 9:39 a.m. and 9:46 a.m. on April 3rd, 2003. I've done that. But further investigation will be necessary to answer your specific question.
So you're not saying this is just prosecutorial incompetence. You're alleging something worse.
Yes, the district attorney would like to speak to that.
All right, this is the report detailing Alfred Brown's investigation, the reinvestigation, and the determination that's been provided me by the special prosecutor. The allegation of professional misconduct was made by the district attorney's office, this office, specifically by Judge David Mendoza on my behalf as district attorney. It was filed with the State Bar, and we alleged 3 areas of misconduct that Dan Rizzo had committed. There's another question that needs to be answered, though, and that is whether the conduct rises to the level of criminal activity. There's also a conflict of interest question. I know Dan Rizzo, and I have for 32 years. I've been friends with him. Everyone or many people in our office are in the same position. And so it will be up to a judge to determine whether I've got a conflict of interest, and who, if anybody, then would be appointed what's called a pro tem to look into the conduct of Mr. Rizzo. Many of the claims or criminal acts that could potentially apply are time barred. But the final determination really should be up to someone without a conflict of interest. So we do intend to, or John intends to file an additional complaint with the State Bar because that is not time barred. And the State Bar, in considering Dan's conduct during the last complaint and their response, they did not have the benefit of Mr. Raley's report. And I had not accepted his findings of legal innocence for Alfred Brown, which I do now.
You said you anticipate that there's going to be some opposition to this determination. Can you share with us who you think that might be?
Oh, well, since the beginning of the request, the police union has opposed and requested us to consider evidence that either they brought or others from the police department brought. Because we work with the police department every day, we did that. John has worked with the homicide division throughout his investigation. I have met with them. I anticipate that they will disagree. And what I want to assure people is that police and prosecutors disagree every day on charges, on evidence, on punishment, on nearly every aspect of the criminal justice system. This does not mean that we're in alignment or opposed to one another. At least that's how I feel. And in talking with them, they, like us, are bound to the evidence, but it was one of their own who was killed, along with Alfredia Jones, an innocent woman whose only crime was to have a job at Ace Check Cashing Company. So I anticipate that there will be comments from them. I want to say this about the crime victims. The crime victims were contacted by my office, by my two top deputies, Tom Berg, First Assistant, and Vivian King, Chief of Staff. I've been a crime victims advocate for many years, really most of my career. I'm the daughter of a crime victim. My obligation as an advocate is not to tell people what they want to hear, but to tell them the truth. And that's never easy. And so, in that regard, I want to tell the families of the victims that I understand their anger, their frustration. I can understand it being directed at us. That happens. But it does no justice to your loved ones to have a wrongfully convicted person forever tainted by what a prosecutor did in this case. I think it's important in looking back that as the elected DA, we hold everybody accountable in this case for the injustices that have occurred to the victims and to the accused. And that's why further inquiry into then Assistant District Attorney Dan Rizzo's conduct is necessary.
Will there be a review of former Assistant District Attorney Rizzo's previous cases?
When and if individual claims are made, we'll look at them. But our office hasn't the capacity, as does no district attorney's office in the country, the capacity to endlessly review individuals' cases. But if and when individual writs or claims are made, then that's what our Conviction Integrity Division does. Just like in the case of Officer Goins, we have an obligation forever to get to the truth in every criminal case. And that's what we'll do.
Do you have a time frame for reviewing the cases in officer cases?
No, I have no time frame at this time. I mean, the investigation is still ongoing of the current case. So a review of past cases will occur, but I can't give you a timetable today. I can tell you that it'll be a thorough review.
Have you guys talked to Alfred Brown and his family?
I have not talked to Alfred Brown since I saw him back in 2016 when I was campaigning. I've talked with some of his lawyers in the interim, although that's been some time about this case. While this investigation was pending, I did not speak to Mr. Manny or Mr. Stolars or any of the plaintiff's lawyers in his civil case.
What is the status of the civil case? I mean, I know
They were stayed by the judge pending Mr.
settlement.
I'm sorry?
Are you looking at a settlement in light of this report? Or?
Well, Harris County right now is represented by the county attorney's office. While I'm a named defendant, that's just another way. It's in my official capacity, not in my individual capacity. So because we were sued in my official capacity, the county attorney is representing us. The county attorney has taken a different position prior to this report. The county attorney does not yet have a copy of this report. If this report puts us at odds with the county attorney's position on the civil case, then I will move to have another legal representative in that case in my official capacity, because I accept Mr. Raley's findings. I hope that the county accepts Mr. Raley's findings.
Mr. Raley, what do you say to the fact that, you know, the union folks are already saying you don't have the experience to look at this in the first place, and then they wholeheartedly disagree with your findings, and it feels like this is a travesty for the family. What do you say to them?
First, I have great respect for the police officers in our city, and I thank them for their service. I come from a law enforcement family. My father who is deceased, was a prosecutor. My brother is a career prosecutor. In working up this case, I worked very closely with homicide detectives, gathering all of the evidence that I could. I understand that some people in the police union have questioned my experience, and they're entitled to their opinions, but I wish that they would consider that I have worked on several murder cases where law enforcement was completely convinced of someone's guilt, and they were wrong. If the prosecutor in Williamson County had had his way in the Michael Morton case, not only would Michael Morton still be in prison, but a brutal murderer named Mark Allen Norwood would still be at large, able to kill other people. And in fact, he'd killed another young woman after killing Christine Morton. And so sometimes human beings get things wrong. But I have a great deal of experience in handling high-level murder cases, and that's a matter of record. They're free to review that.
Do you know any?
Excuse me? I think that would be an appropriate thing to be considered. Certainly further investigation is needed regarding certain things which I've laid out in my report, and that would be one option to consider.
We're here for Brown, but can you speak to the magnitude of this? It seems that you're saying that the prosecutor got both cases wrong, that the wrong people were convicted in both murders of Alfredia Jones and Mr. Brown.
The thrust of the report is Alfred DeWayne Brown. The evidence shows that he was not present at the crime scene and therefore is actually innocent of the charges against him, could not have been guilty of the murder of Officer Clark. It had to have been someone else besides Alfred DeWayne Brown. That was certainly wrong. Regarding Alfredia Jones, Jobert was convicted of that based on the testimony of Glasby, who was allowed to testify that he, Glasby, loaned his prize .45 that he loved showing off to everybody with a laser sight and loved loading and showing everybody that it was loaded. He loaned that to Jobert and went into the murder scene unarmed, went into an armed robbery unarmed after giving Jobert his gun. We know from the evidence, from the forensic evidence, that Alfredia Jones was killed with Glasby's gun, and we know that he bragged to 3 people that day that he killed her personally. So there is strong evidence that Glasby was the murderer of Alfredia Jones.
I want to address that, please.
Yes.
Jobert's case is still pending in the form of a writ of habeas corpus. It is ongoing litigation. So without getting further into that case, it's something that myself, our writs division, and lawyers on the other side will look at. I don't think I'm at all prepared to conclude anything in that regard. That was not the thrust of Mr. Raley's report. But it is something that he feels strongly about. I did not change his report. I did not request him to change the report. I did not tell him what to find. Mr. Raley was selected because he was not just Michael Morton and Hannah Overton's lawyer, but because he's been a civil practitioner and is a well-regarded lawyer in other realms as well. With regard to Michael Morton's case, a murderer had been on the loose for decades without being brought to justice in either Mrs. Morton's murder or in his other, at least one victim's murder. Through the work of John Raley, that murderer was convicted in 2 separate counts. I think that that goes a long way in talking about what the value of bringing a case like this, what the value of really investing in a second look, a third look, a fourth look, if that's what it takes, in a case of this magnitude. You know, this was a death penalty case. 2 people received the death penalty, and 2 people died. And so I think getting to the truth of the matter is what we're charged with doing, regardless of how long it takes and how many lives really were affected.
Is there an active investigation by HPD as far as you know to find the real, I mean...
HPD like in every case where there is not a final resolution, should consider it an open investigation. We do, but I don't speak for HPD. Art Acevedo speaks for HPD. We did meet with the chief. We met with his homicide detectives. It's not that it was an easy meeting. It wasn't. But it was a necessary meeting, just like John met with those investigators. So I'll reiterate, police and prosecutors disagree every day. We have different jobs. Ours is to determine whether the legal standard can be met by the evidence that's provided, and whether through any additional work we can obtain other evidence. That's exactly what we did in this case. The system has worked in this case. Alfred Brown was wrongfully convicted through prosecutorial misconduct.
One thing to add. Regarding the HPD, I have worked with the chief homicide detectives assigned to this case since May of last year. Have had many meetings, phone calls with them. They have been extremely helpful to me in supplying evidence that I requested. Never once have they declined to provide me with specific evidence that I requested, and the ability to interview certain witnesses. So we've had a very cooperative relationship. I can't speak for what their opinions are or are not. Our report is very factual. I am hopeful that they and everyone will read it with an open mind and draw their own conclusions from the facts that we've listed. Yes, ma'am.
The Michael Morton case that you're involved in tends to be held up as, you know, the one case where the prosecutor was actually somewhat punished for what he did. How does this case compare to the Morton case or the Hannah Overton case or the other wrongful convictions that you've worked on?
I can speak to some degree on the Morton case because I was heavily involved in it. I can't speak to the Anthony Graves case because I was not personally involved. The Hannah Overton case I know about, of course, because I was involved in it. But regarding Morton, the man who convicted him at the time of trial, District Attorney Ken Anderson, 25 years later was a sitting district judge. Because of the evidence uncovered in the Morton case, he was removed from the bench, disbarred, and served time in jail for concealing evidence in a murder case. He denied throughout that he had done so. The evidence was in his file. There was a dispute between him and the defense lawyers as to whether he had provided it. The evidence was strong that he did not provide it because if he had, they would have tried to use it at trial. But there was a dispute. In this case, it is a matter of public record, and we've laid out in our report that ADA Rizzo was informed that there was evidence consistent with Brown's alibi that was in his file that was available to him. And this evidence was not produced to the defense or to the court. And it cannot be a coincidence that the one piece of evidence that there is an email saying this is consistent with the alibi, this is exculpatory, is also the evidence that went missing later. How that happened requires further investigation, but we know from 3 witnesses, including a U.S. Deputy Marshal, that at one time it was in the official file, and later it was missing. Yes, I think it's a stronger case against ADA Rizzo than we had against Ken Anderson, based on that evidence.
I want to just follow up on what you were saying with the homicide detectives. Have they seen your report? They know the outcome? Are they disagreement?
They have not. I made edits to the report as recently as yesterday, so it is now final because it has been bounded, and I've submitted it to the district attorney. They may have some idea where I'm coming based on some of the questions I've asked. I don't know, but they have not seen the final version. I have discussed many, many things with them. Yes. Yes, sir.
The State Bar has not taken any action at this point on ADA Rizzo, or what is the status of it?
The State Bar received a grievance that was filed by District Attorney Ogg. They did a summary dismissal without reaching the evidence. There was no litigation. it is my understanding that that is not dispositive, that does not prevent an additional grievance or an amended grievance based on new information. We certainly intend to provide that information to the bar, specifically this report, which you are all going to see very soon. And my understanding is that they have the ability to consider that information and make further decisions.
Anything further?
I'm sorry. What do you see, was there some common thread in the cases that you've handled with this one as well? Something that went wrong in these
Yes.
cases? How does something like this happen?
Thank you. In every one of these murder cases that I've worked on where there was a wrongful conviction, the prosecutor early on jumped to a conclusion that someone was guilty without considering all of the evidence. And then having made that decision that someone was guilty, having made himself or herself the judge and the jury, then future conduct was driven by that decision. Evidence that supported the decision they'd already made was lifted up. Evidence that was inconsistent with their decision was discounted, sometimes even concealed, because they told themselves that the ends justified the means, and we can't let this murderer get away. And if they had this evidence, well, the murderer might get off. And that's when sloppy work becomes professional misconduct, prosecutorial misconduct. But in every one of these cases, it starts with jumping to quick conclusions without considering all of the evidence. Sherlock Holmes will tell us the first thing to do is get all the facts and then have theories based on facts, rather than have a theory first and manipulate the facts to fit your theory.
Thank you very much.
Any other questions?
I have one more question off topic. We had another crash today, deadly crash involving possible over-serving at the institution, a local bar that we introduced recently. What's your office going to do to try to prevent this seems to be epidemic of over-serving by bars and certain languages?
Well, I'm glad you asked. As the media probably knows, we hold regular press conferences warning people that there will be extra DWI enforcement on a particular weekend or a particular holiday. But our office went further. When I came in, I was interested in getting to the source of crimes, not continually treating the symptom. So you can arrest drunks all day long who are driving, but it's important to know if there are establishments that are illegally serving them who cause that to happen, if they have a fatal or terrible crash, that those institutions be held accountable. So we do what's called source investigation. And when investigators determine that the accused individual, somebody who was a drunk driver and killed another person or seriously injured them, has just come from an establishment, we've begun in our task force, TABC and other law enforcement agencies, investigating those restaurants and bars. All restaurants and bars are well aware that their servers should not serve drunks, that they should ask for legal identification, etc. And the only cases that we've brought are cases not where there's been a close call, a fake ID, something like that, but where the evidence shows that the servers absolutely knew the person was drunk or they absolutely knew that the person was a minor. In those cases, we think there's sufficient evidence to hold them accountable for those crimes, in addition to holding the drivers accountable for the deaths or the injuries they cause. Thank you for that question. Thank you.
We have hard copies of the report over with Dane on the other side, and they'll be online on the website by
You bet.
this afternoon.